Marital assets do not automatically avoid the probate process and go directly to your spouse. If you have a house that you own with your spouse, it is marital property, but that does not mean it avoids probate. It depends on how you hold title to that property. There's typically two ways to hold title. One will be tenants in common. The other one is joint tenants with rights of survivorship. If you hold it as tenants in common, which is typically default when you purchase a property, it will do one of two things. If you have a will and you have it set up so that the house goes to your surviving spouse when you pass away, it will still have to go through probate, and then it will go to your surviving spouse after probate. If you do not have a will, it will get split up per the intestate laws during the probate process, and then your kids and your spouse will typically have to split ownership of that house. And so if you own it as joint tenants with rights of survivorship, it will automatically avoid the probate process. How that's typically set up is each of you own 50% of the property, and then when one of you passes away, your half of the house will automatically avoid the probate process and go directly to the surviving spouse, allowing them to own 100% without probate. If you have tenants in common, you can just set up to be joint tenants with rights of survivorship. That way it avoids the probate process. If you want help setting this up, click the link in the bio, fill out the form, and schedule a time to talk some longer.